Dear audience, my name is Tetiana Nsupova and I'm a senior fellow at the British Institute of International and Comparative Law and a leading researcher of the project The Dynamics of Judiciary in Ukraine in the context of the rule of law and the European Union Accession Aspirations. The project is consulted by the advisory board pro bono, comprising prominent current and former national and international judges. And today, on 7th of November 2024, I am delighted to open this series of interviews with the members of the advisory board and to introduce my first guest, Professor and Judge Paul Lemmens. Professor Lemmens is an emeritus professor at the Catholic University Leuven in Belgium, where he taught civil procedure, constitutional law, and European and international human rights law from 1986 to 2019. He has authored numerous works on interpreting convention rights and their application in domestic law and continues to contribute to university projects and teaching. In addition to his academic career, he served as a judge on Belgium's Council of State from 1994 to 2024, working in both the advisory, reviewing draft laws, and appeals sections. From 2012 to 2021, he was on leave to serve as a judge of the European Court of Human Rights. Currently, he is a chair of the Administrative Tribunal of the Council of Europe. He was also a member of the United Nations Human Rights Advisory Panel in Kosovo 2007-2012 and previously led the Flemish Inter-University Centre for Human Rights in Belgium. He co-founded the European Master in Human Rights and Democratization, now part of the Global Campus of Human Rights in Venice. For many years, Professor Lemmens served as an expert for various international and national organizations, including 2 missions with the Venice Commission on Judicial Reform in Ukraine. Those missions led to 2 opinions published in October 2010 and October 2011. And his next visit to Ukraine was in May 2015, within the framework of training for judges of the Supreme Court, with the presentation, the role of the Supreme Court in the implementation of the European Convention of Human Rights and the execution of judgments of the European Court of Human Rights. The last visit, during which I had an honor to meet you, Professor, was in 2016, and it was a visit during which you participate in a roundtable with Ukrainian judges in Odessa in September 2016, within a presentation on the trial on the right to a fair trial. So thank you so much, dear Professor Paul, if I may, for accepting this invitation for the interview. And let me start with a very general, wide question, but in my point of view, very important to those who never have been in Ukraine. I would like to ask you, given that you have visited Ukraine multiple times, you likely formed general impressions on the country and its people. And did Kiev strike you as a modern European capital? How would you describe the mentality, values, and I would say multi-leveled identity of Ukrainians and their cultural code? The floor is yours.
Yeah, a lot of questions.
Yes.
Let me say that before I went to Ukraine or participated in missions of the Venice Commission, that was indeed in 2010 and 2011, I had been already, I think, twice before to Ukraine. That was in the 90s. And at that moment, I think it was in 1996 or 1997, it struck me that this was, at that time, a country still very much under the influence of the Soviet past. It was typically a country in transition. I was at that time also very much interested in transitional justice, and I could see that transitional justice was being put in place in Ukraine. It's a difficult path towards all sorts of reforms, economic reforms, legal reforms, but also societal reforms. Society that came out of a very dark period, to say so. Later, when I went back to Ukraine and when I participated in these missions of the Venice Commission, I saw a country and a city, Kiev, that had gone already a long way. Kiev clearly wanted to be a modern city, and that was very visible. And I hope that Kiev will become a very modern city, but I hope also that it will continue to cherish the positive aspects of its past. And here I'm referring to the fact that I remember that when I was in Kiev in 2015, again, as you mentioned, I walked around the Maidan Square, but I remember also that I went through small streets in Kiev, in its historic center. I thought that was a very interesting experience for me, and I hope that these places will also be preserved. Now, as far as the citizens are concerned, well, something that also struck me, and for this whole period that I was involved with Ukraine, it's a thing that is not typical for Ukrainians only. That is something that I have observed with other people that have been under the Soviet rule, a fundamental distrust of the authorities, which strikes me because I would say in Western Europe, generally speaking, it's the opposite. We trust our authorities. We think that our authorities will take care of us. They do not always do it in a correct way, but the starting point is we have these democratic institutions and we can trust them. In Ukraine, it's exactly the opposite. Authorities, all sorts of authorities have to be distrusted. It means, of course, that all the abuses that have taken place during the Soviet era, that they have deeply affected the people and continue to affect the people. I hope that that situation will change, that one day people will be able to also have trust in their authorities, but that will take many years and also generations of officers who see their office as a service to the country and not as a means for personal enrichment, etc. It's a question of mentality, and it takes time. Finally, I have not been in Ukraine since the eruption of the war in 2022. I have to mention this. This, of course, is now very important for Ukraine. My heart is with all Ukrainians who have suffered and who continue to suffer because of that war. And I hope that peace can be brought to your country so that life can return more or less to what is normal. But I love your country.
Thank you so much. Thank you for your contribution and for your thoughts, which probably describe life in Ukraine, as it is from different perspective, from outside perspective, because of course we understand our Soviet heritage has influenced a lot and still influencing. And the topic you mentioned about trust to authority, including judiciary, it is a huge topic for discussion, which affects actually, all aspects of life of Ukrainians. And unfortunately, judiciary is a branch of power, state power, to blame all the time, which brings new reforms and experiments with the judiciary, which not always good for capacity building. And I would say, considering that your visits to Ukraine were before and after the Revolution of Dignity, which happened in 2014, have you observed any changes in the judicial landscape, considering that huge number of transformations and reforms, and as I said, even experiments with the judiciary in Ukraine? Have you noticed any, changes for better or for worse, maybe?
Yeah, I think that there have been improvements, and I saw also a certain development that is still going on, of course. When I visited Ukraine for the first time in the 90s, I was struck by the fact that the Procuratura at that time had such an enormous influence. An influence over society, but also a sort of authority over the judiciary. And that was strange, coming from Western Europe, where we consider that in that relationship between prosecutors and judges, it's always judges that have the last word, and the prosecutors, they bring applications before the courts, but it are then the courts who decide. In the beginning, when I was there the first time, I don't know how it is now, but certainly at that time, the Procuratura, in my opinion, played a too important role. When I later visited Ukraine with the Venice Commission, what did I notice then? I noted not only with my visit or with our report, but also already in previous reports, the Venice Commission did not trust the High Council for the Judiciary because it was too politicized. And that was due to the composition as it was regulated in the Ukrainian constitution. It seemed to have more trust in the High Qualifications Commission, where the majority was were judges elected by the Congress of Judges, but then it also saw that the recommendations of the High Qualifications Commission could be overruled by the High Council for the Judiciary. So was not so happy with that situation. I noted that there was something strange going on with the Supreme Court. The Supreme Court, according to the Constitution, was the highest court of the country, but at that time, that status was being circumvented by the existence of 4 high specialized courts, which were in fact cassation courts, which took the power from the Supreme Court, and the Supreme Court was left with some residual power, which was not so important anymore. I think that at that moment, or in that period, there must have been a big distrust in the Supreme Court. I know that at that time there was corruption, there was also a huge backlog, and the Supreme Court was not able to perform its job in a way that could be expected from a Supreme Court. At that time, also the appointment and dismissal of judges was something that was organized in a much too politicized way. Again, it was the Constitution that provided for it, but okay, it's not only the Constitution, it's also, of course, the way how the provisions of the Constitution are being applied. And finally, the system of judicial self-government was put in place, but it was too complex to work effectively. I would say that for many years, probably after the independence of Ukraine, the judiciary was still seen as a sort of a judicial arm of the state powers. Or to put it differently, the state powers were very much tempted to put their nose in the activities of the courts and to try to influence the judicial work through the appointment of judges, the dismissal of judges when they were not doing what was expected from them, etc. This is not exactly the idea of a judicial branch that is the third power in the state, that is there to protect anyone who wants the protection of the law. And in many cases, that will be citizens who want to be protected against more powerful citizens, entities, the state, etc., etc. Now, after the Maidan revolution of 2014, I noted that there were important amendments to the constitution in 2016, which cleared the path for further reforms in line with acceptable European standards. The Venice Commission has said many times, you cannot do that without a change of the constitution. And so finally, in 2016, that door was unlocked. That was now situation made it possible to have good reforms. And a lot of measures, a lot of reform measures were adopted. But I went through a number of Venice Commission opinions from around that time and after that time. I get somewhat lost in the reforms. It is difficult to see what exactly the end goal is. To be very specific, what, for instance, should be the role of that High Qualifications Commission for the Judiciary and the High Council of the Judiciary? What should be the relation between them? How should the structure of judicial self-governance look like? There have been too many fragmented measures, which often also remain unimplemented. And one has the impression that following a presidential election, a new program has to be put in place with changes by the new parliament and the new government. The Venice Commission itself has also often said stability is needed for the sake of legal certainty and also for the sake of the independence of the judiciary and the trust that people can put in the judiciary. That is one thing, this continuing process of reform. I understand that corruption is still a problem within the judiciary, even in the highest positions of the judiciary. And of course, that undermines everything. If there is corruption, then how can people trust the judiciary? I think that given this long history of new and unfinished reforms, like the Venice Commission, I think that a new and holistic approach to all the problems is needed. I would say, I don't know whether that is possible in the Ukrainian context, but in order to be something that can last for a longer period than the presidency of one president, to say so, I wonder whether it would not be possible to undertake a reform based on a wide cross-party political support. Perhaps a commission of parliamentarians, judges and academics to sit together to prepare a draft, which then can be sent by the government to Parliament. We in Belgium, we had a big reform in the 60s and the 70s. It took some time, took a number of years, big reform of the civil procedure and the judicial organization in the country. And because of the immense task, it was given to be prepared by a royal commissioner, as he was called, for the reform of the judiciary. He did not do that alone. He consulted all the stakeholders. And then finally, when everyone agreed, a draft judicial code was sent to Parliament and was then easily accepted by Parliament. And it still continues. Of course, it has been amended in the meantime, but the basic principles are still the principles that were then adopted. So this is maybe an idea for Ukraine. Finally, one thing that I also would like to say, I see that that's also a development that is taking place, and I think it's a good development when it comes to the vetting of individual sitting judges or the selection of new judges, when it's about individuals, not about general regulations, but about individuals, it might be good to involve non-Ukrainians, foreign experts in the process. That can help. It's not going to be a guarantee for success, but that can help to avoid undue political influences, because normally the foreigners will not be aware of what allegiances are of individuals, and they can decide or make recommendations without having to look at the political parties, etc., etc. It's a sort of a guarantee that has sometimes been useful in other countries, including in Eastern European countries. So that's in a nutshell how I have seen that there were problems from the very beginning, that there were all sorts of attempts and ongoing attempts to tackle these problems. Problems are not solved, and there is often a disagreement with what has been attempted by a previous regime, to say so. So the solution, I think, should be, let's do it a bit differently, and try to involve all stakeholders at once in an attempt to reform the judiciary, I would say, for once and for all, although that is, of course, a wish that cannot be guaranteed.
Thank you so much, dear Paul, for such a comprehensive explanation. And of course, I would like to reflect to what you said.
Yeah, well.
Yes.
No.
I do support your idea of consolidation of efforts and cross-party approach, as you said. And the thing is that we formed already, the most comprehensive judicial reform was started in 2016, actually in 2015, by setting up a constitutional commission, so to speak, which included academic society, presidential office, all stakeholders, as you said, who are interested in judicial reform. And it was started with the reform of the Supreme Court. I will explain a little bit later what it was, and as well reforming the court system from 4 levels to 3-level court system. And you mentioned previously that it was a confusion between the Supreme Court and cassation courts. So this system was transformed into 3-level system with the Supreme Court on the top and the Grand Chamber who would address the most serious legal issues and trans-jurisdictional issues. And it included, and I was a part of it, I had an honor to be part of, to be a member, a judge of the Grand Chamber. So we would consider cases on civil, criminal, administrative, and commercial jurisdiction, all categories of cases, but the most valuable for forming the judicial practice and court practice. Yes, so the reform, the comprehensive reform, as I said, and as you're absolutely right, was not finished. And that's our issue. We don't have this consequency, you know, this continuation of what we started and where we finish. And the idea is, which exists for a while, that judiciary needs its strategy, which would probably provide that route and protect judiciary and its independence from, you know, external interferences. And that's the idea, but still, who should be the author of such a strategy? In my point of view, it should be judiciary in such, including courts, governing bodies and self-governing bodies of the judiciary as a main author, so to speak. And then we can discuss it widely, and we can form the platform for discussion of such a strategy, including all the stakeholders, as you said. But the thing is that it was already adopted, if I'm not mistaken, 2 such strategies for 5 and 3 years by Poroshenko presidential office and Zelensky presidential office. And it seems like Traditional now that the presidential office is an author for such a strategy, which I'm not considering as a right approach to, so we make the judiciary as an object, but not the subject of planning its own development, its own view of how this reform finally should finish. And again, there is a question still about the coordination of powers of High Qualification Commission and Higher Judicial Council, because yes, we have two bodies for to deal with disciplinary responsibility and HR policy, so to speak, within judiciary. And I know that the point of view of Venice Commission and the Council of Europe institutions is that it should be one body for dealing with these issues and questions. So that's maybe one of the points for us for future reforms. And to tell you the truth, I start to hate the word reforms, because I think we need to improve our system to build the capacity, but we don't need any other, radical changes and something new. And we do need stability. You're absolutely right. The judiciary in Ukraine needs stability to build on it. So you can develop only from the point of stability. You can't, build any improvements or developments if the system is unstable, stressed, and distracted all the time. And of course, it is a huge influence on judges and how they, their capacity, their effectiveness, I would say, even. All the time they are distracted and stressed since 2010, I would say, and reforms haven't finished since that time. So it is a huge influence on judicial independence and effectiveness of judiciary in Ukraine. Yeah, we understand that we've done a lot, and we have that intention towards the European Union. We observed all the values of European values, being a member of the Council of Europe. In comparison with Russia, I would say we accepted and pretty much absorbed these values, because I was surprised that being a member of the Council of Europe for so many years, for more than 20 years, Russian civil society hasn't grown. We finished as we finished, with full-scale invasion and absolutely different understanding of what democracy is and rule of law and human rights. And considering you occupied the position of judge of the European Court of Human Rights, have you noticed this progress, Ukraine's progress as a democratic state, despite still being a high case count country, because I think we're still in 5 top countries? Do you think Ukraine advanced in understanding and implementing European standards of human rights, rule of law, during your term as a judge of the European Court of Human Rights?
Well, that's a bit difficult to give a clear answer to that, because at the European Court, or the European Court, deals with the pathological situations. What goes wrong? The European Court of Human Rights does not give good marks for what is going in the right direction, or what is okay. That would be more other bodies of the Council of Europe. I saw, and sometimes I saw that because I was personally involved in certain cases in the European Court, I could see that there were a number of important issues that were coming from Ukraine and brought before the European Court. That important issues indicating that something was indeed wrong with the judiciary, like pressure on the courts to decide cases in a certain way, pressure from political sides, and probably the cases that came to the European Court were only the top of the iceberg, because it's not always easy to say that such a pressure has existed. A number of important cases were, in fact, thanks to Ukrainian applicants, standards were set in the European Court's case law, dealt with the interference of political bodies or politicians in the dismissal of judges or of presidents of courts. You know these cases: Volkov, the dismissal of a Supreme Court judge; Denisov, the dismissal of a president of an administrative court of appeal. Latter case came before the Grand Chamber of the European Court, not because it was such a spectacular case, but because the Grand Chamber wanted to change somewhat its principles on to what extent Article 8, the right to respect for private life, can be invoked by someone who is dismissed. Then I don't know to what extent it still exists, but the protest system, this kind of supervisory review of final judgments in the hands of the Procuratura, was something that certainly in the beginning came a lot before the European Court. And I think that evergreens are the length of proceedings and the non-execution of judgments of the domestic courts. I think that these problems are not yet solved, these two last problems. The others, I hope that it's getting better, and indeed I do not see systematically coming these cases now before the European Court. So I suppose that from a structural point of view, there have been some improvements. It's not ideal. It's not ideal in any country, but there is still that matter. And of course, that is important for the citizens, that they cannot get a judgment within a reasonable time. And that if they get a favorable judgment, it is not executed within a reasonable time. And one should not underestimate these problems. They are maybe not, at first view, they might seem not to be so serious, but these are the problems that parties before the courts, individuals, sense directly. That affects them. So these are also problems that have to be attacked, dealt with, and that is broader than the structural reform of the judiciary, I think. It's part of it, but it's also broader than that. So I cannot give you a report or a development of or a sort of an assessment over the years. That would be for others than for judges of the European Court, I think, to give such an assessment. But I gave you some idea of what I saw during the years that I was there that were problems.
Yes, of course, we are limited in, giving an opinion on particular judgments or situations. And yes, focusing on your personal experience of communication and interactions with Ukrainian judges and legal scholars during your visits or beyond, maybe, how would you evaluate, if possible, the judiciary's readiness and capacity to support the country on its European way, integration way, considering our Soviet heritage and all the issues and problems we discussed today with the independence of judiciary? Would you think that the perspective is still there, intention is still there, and we are very much looking forward to this development, because I think it's the only civilization way for Ukraine to survive. So do you think we have that readiness for judiciary to support our country on this way?
Yeah, that's an interesting question. And you ask me primarily, what about the judges in the judiciary? Of course, it depends on whom you meet. I think that there are, roughly speaking, two categories of judges. There's one category, and that was a very important category, especially in the beginning, of judges who were very much influenced by their education, their legal education, and by the habits that they had under the Soviet rule.
Mm-hmm.
And then I'm referring to judges who are very much focusing on the letter of the law,
Mm-hmm.
applying it often in a very formalistic way, without paying attention to, I would say, the global fairness of a trial, and to some extent also the fairness of the outcome of the trial. Oh, everything was done according to the rules. So what can be wrong about that?
Mm-hmm.
I think that's somewhat the older generation, because I've met a number of other judges over the years and other persons, and you are one example of these judges who are open to reforms, who understand the role of a judiciary in a society, in a modern society based on the rule of law, a democratic society, where the judiciary has its place. It's an important place, but it's not an almighty place. Judiciary is also subject itself to the rule of law. Mostly judges who made themselves, to the extent that that is possible, familiar with what is going on in other countries, who made themselves familiar with the European Convention and the case law of the European Court of Human Rights, and also perhaps the Court of Justice of the European Union, to see what are the principles, and not only the written law, but what are the principles that we have to take into account. When I met judges of the Supreme Court in 2015 and other judges in 2016, I certainly noticed a willingness among the judges who were there. I don't know how many did not attend and were not interested in attending the meetings, but the judges who were there were certainly willing and interested to know what was expected from them. What could guidelines be coming from experiences in the democratic states of Western Europe and elsewhere? What could they learn from these experiences? And I found that that was a very interesting experience for me to see that. And I think that this gives reason for hope. I think that for many years, probably, that was my experience in the very beginning when I met judges, they were expecting things. They said, we are judges, we can expect that the legislature will adopt certain laws and then we will apply them. I think it is important, as you have also just said when you were commenting on what I said before, that judges also have a role to play. It's maybe not that, and maybe I slightly disagree, maybe it's not for judges to be themselves the motors of the reform. I think any reform is going to be a political act. It's a law. Law is a political act, and political authorities have to take responsibility for that political act. But I think that judges and lawyers and academics, whatever you want, they can play an important role in putting things on the table, trying to move things in a certain direction, not just keeping silent, but taking up also their own responsibility in the reform. And I hope that more and more judges are aware of that role and that they take up that responsibility, not for their own profit, not in order to improve their own position, but always keeping in mind what can the judiciary do for the general interest, for people who are seeking justice in the country. It's an enormously important task. And it requires a certain culture among those who are within the judiciary and who are tasked with that mission, serve the country, serve the citizens of the country.
Thank you so much, dear Paul, for such a honest answer and observations, which I find very fair, because yes, we do have this issue with old school judges and new generation judges, and huge difference between them in education and understanding what rule of law is, what is the judicial activism, judicial diplomacy, and it's sometimes absolutely opposite view on this questions. And yes, I think that at this transformation and very difficult period of time for Ukraine, we do need leaders in judiciary, and we do need a strategy, as you pointed out absolutely fairly, that we should see where is our final destination we would like to reach. So unfortunately, we're very limited in time today for our discussion and dialogue, but hopefully we will have another opportunities. And let me thank you for your expertise and observations, which offer us a deeper understanding of Ukraine's evolving role in Europe, and as well as shared responsibilities and opportunities ahead. And hopefully we do have that capacity to overcome all difficulties and obstacles on our way to a democratic society and effective judiciary. So thank you so much for this conversation. And thanks a lot for accepting the invitation.
Let me thank you. And I would also like to congratulate you with setting up this project, and I hope that it will be successful. It will take some time, and before it gets implemented, it will take even more time. But never lose the end direction out of sight. I think you have all the capacities to do that. And what I just said today is a very modest personal view on certain things. I'm not a specialist in Ukraine. You may listen to what foreigners have to say, but it has to come from the Ukrainians themselves, of course. And I wish you good luck.
Thank you so much. And your contribution is very much appreciated. I will stop the recording now, and I would like to thank the Pickle event team for their technical support. Thank you so much, and thanks everyone for the attention.